Hello, everybody. Welcome to another insightful episode of the UPC Insights, where we delve into the intricate world of patent litigation across Europe. I'm really excited about today's program. I'm your host, George Walden, and today we're exploring the dynamic interplay between the Unified Patent Court and UK patent litigation, with a special focus on the Intellectual Property Enterprise Court, the IPEC, as a cost-effective venue. Joining us are two distinguished experts in the field. I have the pleasure of welcoming a good friend and a comrade of the show, Sam Giles. Sam, welcome to the show.
Hello, thank you for having me.
And Sam Giles is a UK patent attorney who brings deep knowledge of the UPC law as well as the UK patent law. And also, we have Tilman Pfrang, a well-versed in the workings of the UPC. Tilman, welcome to the show once again.
Hello, George.
Glad to have you back. So together, we'll discuss why patent owners might choose to litigate in both courts simultaneously and compare timelines, cost, and strategies, and uncover the nuances of navigating these two legal arenas. Now, this is going to be good. Whether you're a patent holder, attorney, or just keen on the latest legal developments, this episode here is packed with valuable insights. So let's get started and learn how to best manage and leverage the options available at the UPC and the UK courts. Guys, are you ready?
Ready.
There you go. Okay, Tilman, I have a question for you first off. Can you explain why a patent holder might choose to pursue litigation both in the UPC and the UK courts simultaneously, and what are the strategic benefits of this approach? Now, this should be good.
This is a good starting question, I would say. Well, the background is that the UPC simply does not cover the UK. I mean, we all know about the Brexit, and as a result of the Brexit, and very unfortunately, UK is not in the UPC system. This means in a case where you have patent infringement in the so-called UPC territory, let's say in France or the Netherlands or Germany, and also, in addition, you have a patent infringement in the UK, then you are more or less forced to use both courts, because the UPC court would not cover UK and the UK courts would not cover the UPC territory. And if you have, for example, damage compensation, or you want to obtain an injunction, you need to go to both courts. Then the question why you might think about doing it in parallel is, of course, a time issue. I mentioned the injunction issue, so the stoppage claim. You could theoretically start at the UPC, and then 1 year later, you can, after finalized proceedings at the UPC, you can start proceedings at UK court. But then you will lose a lot of time, and you will obtain your injunction much later. So the strategic benefits are first, of course, that you have a broader coverage from the beginning. And secondly, also, you can hope that at least for one jurisdiction you are successful, right? So you have two shots. And in many situations, it's very useful or even sufficient if you can block the competitor in one of the jurisdictions. Wow. I mean, if you are selling cars and the same type of car is maybe a bad example because of the left and right traffic, but maybe an engine for a car, which can be used in both.
Right.
And you want to sell it in Europe, including the UK, then it will be very difficult for the competitor to say, well, we skip UK, we only sell it in continental Europe or vice versa. So you have these two shots, and if you're successful with one, you are successful entirely in the end, at least in effect.
So Tilman, that brings me to one other question then. Since the Brexit, do you see a possibility in the future of the UPC and the UK courts getting together, working together a little bit more cohesively, or do you still think it'll be two complete separate identities?
Yeah, well, there has been some discussion that even after Brexit, the UK could join the UPC system. It's from the wording, it's not 100% clear that UK is excluded. There is an opinion of the CJEU, so the Court of Justice of the European Union, that it might be difficult, but relating to another case. It is not out of the question currently, and I would be also interested in Sam's opinion, actually. Currently, I think even with the political change, it will still be difficult from a political perspective
Yeah,
just
I think
to join.
regardless of law, the politics in the UK of political alignment with the EU, even with something as, let's face it, to most of the population relatively innocuous as patent litigation, I think is something that the UK government is unlikely to pursue despite its clear and obvious benefits, which is unfortunate. I was very much looking forward to the UK being part of the UPC. And it's a shame that that's not the case. But it does also give us these additional complexities, which we'll discuss today, and that it could be useful for patent holders. I think just adding to what Tilman was saying, the other thing, of course, by having both of these in parallel is just additional pressure. If you're exerting a UK patent and a unitary patent over a potential infringer at the same time, they have more pressure on them, and they may be more likely to come to the table, negotiate a reasonable settlement. It's just another way of kind of increasing the stakes.
Wow. I mean, it's pretty interesting that that UK would have the advantage going forward without going back to the European Union as well. But it's kind of really interesting. So that brings me to the next question, Sam. In the context of the UK litigation, what are the different venues available for patent holders, and how does the Intellectual Property Enterprise Court, the IPEC, stand out as an option?
So in the UK, there are 3 forums. I'm going to focus on in England and Wales. There are 3 forums for patent litigation.
Okay.
So the first of those is the UK High Court.
Yep.
I'll discuss all of them in a bit more depth, but this generally has high costs, high recoverable costs, an unlimited amount of damages, and is for larger litigation cases. You have the Intellectual Property Enterprise Court, which generally has lower costs, lower recoverable costs, and a cap on damages. And then you have the UK Patent Office itself. I'm not going to discuss that much further because it's not possible to gain injunctive relief from UK patent proceedings. Okay. So that would very rarely be something that a patentee would seek to use. Going through the High Court, generally trials last for a number of days. There is a short trial scheme which allows for a 4-day hearing. And as of this year, that has a trial cap of £500,000 of recoverable costs.
Wow. Okay.
But that's a new development. I don't think any cases have been filed since the beginning of this year that have gone to completion. So I'm not aware of how well that has worked in practice. But in general, the UK High Court, you would have high costs. So you would have a 4 to 10 day, possibly even more trial. And there was no limit on recoverable costs. So that could be £1 million or upwards.
Okay.
If you were to be on the losing side. But there's also no limit on damages that can be presented. Both the UK High Court and the Intellectual Property Enterprise Court have the same injunctive relief, however. So if the principal thing you're going for is an injunction, there isn't much difference between them. So with IPEC, you have generally lower costs. Trials are generally 2 days. The amount of disclosure between parties and the amount of expert witness is quite tightly controlled in order to reduce costs for both parties. It's often there to try and allow SMEs to have a good forum for patent litigation.
Right.
There is a cap on damages of £500,000, and there are lower recoverable costs of just £60,000 if you are unfortunate as to not be victorious.
Unfortunate.
So clearly that means that you have less risk in terms of bringing an action if you're unsuccessful. Obviously, you would still have attorney costs, but those would be lower anyway because of the lower trial length and the lower complexity with less disclosure and expert witness. And that puts IPEC in an interesting place because whilst clearly you can't bring an action in IPEC that is worth tens of millions of pounds and is totally in the wrong forum, anything that's at least around that level of damages, or maybe is pre-damages, it means that if you bring an action, you have a lower risk associated with it because your recoverable costs against you are lower. So it can be quite an advantageous thing to use. It also depends on who the representatives are on the other side. If you see that the other side has decided to instruct an extremely expensive representative, then you may decide that having lower recoverable costs means that they may balk at not reaching settlement quickly.
Gotcha.
So there are numerous factors as to why you may choose IPEC or the High Court, and each one will depend on the facts of the situation.
Well, okay. So then let me get back to you now, Sam, with another question. Could you compare the typical timelines for resolving patent disputes in the UPC versus those in the IPEC, or how does the speed of adjudication impact the choice of the forum?
So I'm going to split this into two. I'm going to split this into speed to get to a final resolution,
okay,
and then speed to get to an interim resolution.
So
in terms of final resolution, the UPC has been designed to be fast. It's almost its overriding objective is to reach a decision in around 12 months, or ideally less than 12 months from a case being filed. That's extremely fast.
Yeah.
UK patent litigation is not known for being quick. On the basis of the last podcast I did, it sounded like it's much quicker than Austria, but that would probably be just enough.
Very good. Very well said. Yeah.
So generally, IPEC is designed to be quicker because it doesn't have as much expert witness. There's less disclosure requirements. Generally, there's a little bit more argument up front, although not quite as front-loaded as the UPC, where you have to put almost a complete case very quickly into proceedings.
Okay.
So I think generally for IPEC, you'd probably expect 18 months. If you were requesting an expedited trial, you may be able to get closer to 12 months, but I think you would almost certainly get a decision from the UPC first. That is slightly different when we talk about interim measures.
Mm-hmm.
So as I understand it, and Tilman, you may have slightly more experience of this than me, if you're asking for interim measures from the UPC, you can expect a hearing in somewhere around 4 to 6 weeks.
Do you agree, Tilman?
Yeah. Cases so far we have seen should be in that range. Yeah.
So, I mean, last year we filed a request for an interim hearing for one contentious matter, and I think it was less than 10 days later we had a hearing date scheduled in the UK.
Mm-hmm.
We didn't actually need the hearing in the end. We came to an agreement before that with the other side, but I think that shows just how quickly you could reach a hearing in the UK if you did want something very quickly. So it may be that an interim measure could be reached faster in the UK, but a final measure could be reached faster at the UPC. So that could be an interesting interplay between strategy. But the other point about having the UPC finish first is if you have the costs of the UPC effectively up front, and more of the costs of the UK action are going to be slightly later.
Mm-hmm.
And if you reach a final decision from the UPC first, and that is, for example, favourable for you, then the other side has additional costs that are going to be due for the UK to continue defending it.
Okay.
Where it seems less likely they're going to be successful on the basis of the UPC decision. And whilst obviously the UPC is not binding, the UPC is governed by the European Patent Convention, and the UK Patents Act is in accordance with the European Patent Convention. And whilst the legal tests may differ, you would expect the majority of the cases to be quite similar. So if they have these additional costs that are upcoming, then that again gives them another reason to try and reach a global settlement on the basis of the UPC decision and the additional cost pressure of any upcoming UK hearing.
So would you say it's like the pressure would be coming from the strategy or the cost? Some people might tap out.
Yeah, exactly. So if you've lost at the UPC, you've still got some matters going on elsewhere, then you've got to think, well, we could appeal the UPC, but then in the interim, not only are we appealing the UPC decision, we're also having to fight the same battle in the UK.
Right.
And we have those costs upcoming. What are the costs? What are our likelihood of success? Because we have to succeed effectively, as Tilman said, both depending on the technical subject matter, but both at the UK and the UPC in order to really win based on your supply chain or the market you want to enter. And therefore, that just gives another reason to reach a final settlement.
Okay, but then Sam, now that I love talking about money and costs, since we've been talking about it for this particular moment. So the next question would be: litigation costs can be significant, can be a significant concern for parties. And so, how do the cost of pursuing a case in the UPC compared with those in the IPEC, particularly given the IPEC's reputation as a more cost-effective option? I mean, you've pretty much answered a little bit of it, but can you maybe give me a little bit more detail?
So yes, the UPC is designed to have a front loading of costs. So you have to put quite a lot of your arguments up front. IPEC has some of that, but there is not quite to the extent of the UPC. Generally, IPEC only having a 2-day hearing, you would expect, by UK standards at least, quite low costs, and I would expect them to be probably lower than a UPC action that was ongoing at the same time. The other thing is, if you have all of your front-loaded UPC arguments and you have a very similar legal structure, you could hopefully reuse the majority of those arguments in the UK.
Yeah, interesting. Okay.
So, for example, you would expect the same parties to have the same prior art. You would expect the same parties to advance very similar arguments. Tests may differ slightly. For example, inventive step, the UK has the Pozzoli-Windsurfer test, but ultimately the law is very similar.
So would you say if you get a ruling from the UPC, it would basically be the same for the IPEC or not?
It won't be the same.
Okay.
It's not binding.
Okay.
And some of the legal tests will differ, but the judge would definitely take it into account that there is a UPC decision. They will have read it.
Right.
And they would effectively have to say that that is wrong. And that can happen, but in the majority of cases, it's likely that a similar conclusion will be reached. But in terms of being able to reuse your arguments for at least a majority of matters in IPEC after having already advanced them in the UPC, that does mean that the general cost should be lower, and you should be able to be quite cost efficient in any IPEC action that you bring. So
I got one more question for you, Sam, before I get to Tilman. What are the potential outcomes and remedies offered by the IPEC, IPEC compared to those available through the UPC, and how could these influence a plaintiff's decision to litigate in one court over the other? Now that's the key question.
So both have injunctive relief, obviously for different territories, one for the UK and one for the relevant EU member states.
Okay.
But both have at least an element of recoverable costs. As I've already said, in IPEC, that is £60,000 cap. The UPC has a cap that differs based on the value of the claim. So for small claims, it's quite low, and for large claims, it's quite high. Interestingly, the recoverable costs in the UPC, whilst they're set out, there is also an article that allows them to be adjusted quite significantly based on the fact of the case. I don't think we've really reached that yet with the UPC, but it will be interesting to see how that is implemented. I think in general, obviously the caps in euros to pounds and the cap and the damages are slightly different, but they're in similar-ish ballparks, just to try and allow access to justice for smaller parties.
Very interesting. I was curious. It's interesting to hear you say that, because it sounds to me like nothing is safe as far as if you have one with the UPC or with the IPEC, you never know what you're going to get. Is that a fair
statement? The UPC is just a very young court. We haven't had cases go all the way through to a first decision and then be appealed and then a final decision. Therefore, we don't know exactly how all of the costs are going to be
divvied up,
decided on in the future. Yeah. I think once we're 2 to 3 years down the line, it will be more of a cookie cutter case, and we'll know exactly what to expect.
That's going to be interesting. Yeah.
But we've already reached that case with IPEC. We pretty much know that you bring a case in IPEC, and you're going to have, if you lose, you're going to get less than £60,000 awarded against you. Now, if you're already bringing a UPC case, that's not a huge amount because of the costs that you already have.
Right.
If your costs for bringing a UK action can be lowered through cost efficiency, and you have a relatively low risk profile, then it seems like something that could be added in parallel with it, with the UPC action, without either breaking the bank or increasing your risk significantly.
Okay. Tilman, I have the last question for you. Thank you for being so patiently waiting. Tilman, give me the complexities of navigating dual litigation in the UPC and the IPEC. What advice would you give to patent holders to effectively manage their cases across these two forums?
In the end, it's a bit about whether actually the complexities are so detrimental for your case. I mean, I could also imagine that, let's say the patent holder you're thinking about litigating in the UPC territory or in the UK.
Mm-hmm.
And then I've heard about that people just Google litigation in the UK. And then if we don't have this very valuable information from Sam about the IPEC and all of that, they might come to the conclusion, well, there's costs of several millions, and even if they Google cost risk, then it's about the potential coverage. Can be even more damage, can be extremely high, and that they would say, well, it's much more risky than the UPC litigation, which, however, covers much larger territory. Therefore, I will keep it at the UPC. Don't even go to the UK, to the court.
Wow.
And therefore, I think all this information from Sam are extremely helpful, because there is this IPEC court. So definitely, you should always think of having a parallel proceedings at the IPEC specifically. And you should consider that the £60,000 cap for cost recovery and all of these things can really lead to a manageable cost risk situation. That's at least the lesson I learned. And therefore, complexities, yes, but on the other hand, Sam mentioned this, you can use a lot of your arguments very likely also in the UK.
Right.
And therefore, you can even take another point of view and say, well, there's less complexity because you have a lot at hand already prepared.
Right.
Both are front-loaded proceedings. And therefore, if you start at the UPC and maybe some weeks later at the IPEC, I think this could run very smoothly in the end.
It's okay. Interesting. All right. Sam, do you agree?
Yes, I think it's a strategy we'll probably see more. I think you've already seen with pre-UPC there being UK and German actions in parallel. Sometimes also involving other jurisdictions, but those have traditionally been the two key European litigation forums. And whilst that will likely continue, there is this option of the UPC may in tandem with the UK be another option for enforcing rights. And because of the way that at least some UPC actions may also be in English language, that does then
True.
lend itself to to those arguments being used almost verbatim in two forums to save cost.
Right. Okay. Well then, gentlemen, I want to thank you both. That'll wrap it up for this edition of UPC Insights. And I want to thank once again Sam Giles for joining us from the UK. Great listening to you. Great hearing your points of view on everything. And thanks for being with us today.
It's always a pleasure.
Thank you. And of course, I want to thank Tilman Pfrang, also here in our German offices here, and a guru of sorts for the UPC movement. Thank you for joining us, Tilman.
Thank you, George.
Yeah, so we will be bringing you more distinguished UPC representatives and guests in the near future. You know that. All of us at the UPC Insights are really happy that our listeners took the time out once again out of your busy schedules to join us today to listen to Sam Giles and Tilman Pfrang and their discussions today. It was very interesting. So we have a lot of great UPC Insight content from past shows that are more relevant and exciting than ever. And of course, today's show, which is really one of the fascinating insights that we've had so far. So we urge you to check them out on our YouTube channel or our website at meissnerbolter.de or meissnerbolter.com. If you have any questions whatsoever about any UPC Insight topics that you would like us to talk about, then let us know. Feel free to contact us. Until next time, for Tilman Pfrang, Sam Giles, I think we can all say it together. See you soon und
Auf Wiedersehen.
Auf Wiedersehen.
Auf Wiedersehen.